Hey, Natalie.
Hey Scott, how are you?
Hey, Marion.
Hello, Scott. Pleasure to have you. I'm going to start this. Natalie, you are a candidate for the juvenile court judgeship that's open because of Paul Young's retirement. And would you start out telling us a little bit about yourself and why you're running for this position in the juvenile court?
Sure. I'm Natalie Howell. I have lived in Shreveport for over 14 years. My husband and I met at LSU Law School. I attended LSU undergraduate as well, and followed by LSU Law School where we met. We're actually celebrating 14 years of marriage today.
Congrats.
So, thank you. So we moved here. We chose to move here. It was a year after Katrina, and I knew I wanted to work at the DA's office, and he does oil and gas title work. And we moved to Shreveport and have absolutely loved it. But we just recently bought I hate to say your final home, but essentially where we plan to raise our family and live until we, either die or move into a retirement home. But nonetheless, that we have two beautiful children, and Hampton, my son, is 9. And my daughter, Harper, is 6, and Hampton goes to Fairfield Elementary Magnet, and Harper goes to St. Mark. And we are concerned, the main reason I'm running is I want Shreveport to be better and safer. I hate hearing people refer to it as a ratchet city. I hate people saying Shreveport is a dying community. I hate hearing people encourage their children to settle and move and raise their families anywhere but here. Please go away, move away. Shreveport has no future, and that makes me very sad because I love Shreveport. And so I worked in the DA's office for 8 years. After when we moved here, I clerked for Judge Jeanette Garrett and Justice now Scott Creighton when they were on the district court bench. And then I moved to the DA's office and was there for 8 years, 6 of them in juvenile court. And I've done every type of work to be done at juvenile court via the DA's office and what they are involved in. And then for a little over 4.5 years ago, I switched and I began doing criminal defense work with Eric Johnson. So I practiced criminal defense across North Louisiana. We go everywhere, or did go everywhere. So I've done juvenile and adult criminal defense as well as adult and juvenile prosecution. And when I was approached about doing this, my initial reaction was no, thank you, that politics are not for me. And that's not my plan. And the more I thought about it and prayed about it and spoke to my close friends and my husband, I felt like if I want things to be better, then I need to be willing to step up. So here I am, not a career politician. It's been, the political part has been difficult with the campaign, but I guess anything worth doing is difficult, right? So that's me. I just want things to be better and safer here. And I feel like a large portion of our crime problem is juveniles, and I would say probably 85% of the crimes committed in Shreveport are people 35 and under. And so that's people that have come out of juvenile court and continue in the adult criminal justice system. So I feel
How many judges are there in juvenile court, Natalie?
3. There are 3. There's Judge David Montock. He is the chief judge. And then there's Judge Ree Casey Jones. And then there's Division B is currently held by Judge Paul Young, but he is retiring at the end of the year.
I know in district court they divide up caseloads by either seniority or do they do the same way in juvenile? Some of them get domestic, some of them get criminal.
Currently, Judge Matlock does all of the child in need of care cases, which is the abuse and neglect, working alongside DCFS. So when they do a removal for abuse or neglect, it comes to the DA's office and is prosecuted and through disposition when they decide what the child's plan is going to be, and then they're monitored and reviewed by the attorneys for DCFS. But the DA's office is a gatekeeper essentially, so that I think the idea is so that there's more fairness. You avoid overzealous. I think is actually how it's written, overzealous caseworkers. But I don't think that's ever been an issue. It just allows the DCFS attorneys to focus on TPRs and reviews since it's their agency that makes the plan. So Judge Matlock handles all of that, and then currently Judge Young and Judge Casey Jones, they do all of the criminal. Every delinquency case in the parish goes to one of the two of them. But there is a local rule at Caddo Juvenile Court where it's called one judge, one family is the practice. And so with that, if you've ever come to juvenile court before, that family, let's say if there's an older sibling, you return to that judge. So if there's a group of 20 children arrested for, let's say, a fight at school, all of them, every single one of them are going to go to the judge. If any of the children have had a previous case at juvenile court, then all 20 of those cases are going to go to the judge that had the child before. So currently, Judge Young, just by tenure, because he's been there so long and had so much contact with different families, he tends to get the higher caseload just by way of, I guess, like tenure. He just has had more interactions with more people over the years, but it works out pretty well, I would say, once a new person comes in. I mean, Judge Casey Jones has been there about 5 years, so it will even back out, but it's not like 5 years and 20 years.
Let me ask a question, please. What, in the current system, do you see that you would want to see modified if you were the elected judge?
My concern is keeping children out of the adult criminal justice system. That's my biggest goal, is to keep as many juveniles out of the criminal justice system. And to do that, I plan to hold parents and children accountable. If I have to raise my children, they have to raise their children. If I'm responsible for making sure my children are making good choices and doing what needs to be done to stay out of the criminal justice system, then I feel like all parents need to do that. That's just what I believe. So my plan is, I fully believe in diversion programs. I think they are fantastic, and Caddo Juvenile Court has amazing programs, and I'm very grateful. I have no desire, so I'll say that, to be in district court. I've never wanted to do that. I think so many great things happen at juvenile court, and I want that. I think that should continue. I think we can do more. But my goal is to, once, let's say a child comes in and does diversion, everything's great. Hopefully that gets their attention and we don't see them back. But my plan is, I feel like I agree in second chances, third chances, and possibly, sometimes fourth chances. But I also believe that each time that you come back to court with a new incident, the consequences should become harsher each time, or you're never going to.
If you're going to hold parents accountable, and we know that some of these, the majority, come from single parent or grandparent households where the single parent is holding down 2 jobs with 3 or 4 or 5 or more children, sometimes multiple delinquent children. How do you hold the parent or grandparent or foster parent accountable?
Well, foster parent, that's a completely different situation. If a foster parent is not monitoring their children, that's up to DCFS is going to change that placement. That really doesn't have, the judge doesn't choose which child goes to which foster home. That's a DCFS decision. So, and if the child is in there, they're in the custody of DCFS. So those, I think are solved a different way. But let's say for let's say normal child, I struggle. That's probably the thing I struggle with the most is I understand how difficult it is to raise children. I cannot fathom doing it alone. And so I have every single bit, I have so much respect for single parents. Like that, it's hard working one job with 2 children and a husband that helps me, much less if I didn't have a husband who helps me, I did not have a job that paid well. I certainly don't work 2 jobs. So I do understand that it is difficult. But if let's say there are situations where you tell a child, because we all know there's not a large number of beds that are in secure facilities in the city nor in the state, and there's nothing to be. That's not my choice, and I don't have anything to do with whether they build a new jail or not. That's not an issue for me. However, what I do know is that most of the children that come through and are adjudicated delinquent are going to be addressed on probation. And I think that's great, and I think that they can be. When I say I'm going to hold a parent accountable, when I say your child is going to go to this class that we've set up for you, or this behavioral health treatment or this counseling, your child is going to go. We can work on finding you transportation. We can work around your as much we can with the providers. I mean, if there's not a provider at midnight, there's not a provider at midnight, but as much as I possibly can work around your work schedule. However, I know firsthand there are many times that the parents just didn't do it, didn't go. So they'd come back to court and we would say, the judge would say, why haven't you done this? The DA's office would file either a rule to show cause or a motion to modify to remove the child from the home because they're not complying with the court's orders. And I just didn't have time, or my kid just didn't want to go, and so I couldn't make them. Well, that's a problem, because if a child that's on probation that's for committing a crime, if they're allowed to continue doing whatever they want to do, then they're going to continue to commit crimes, and they're going to end up in the adult criminal justice system. If you don't get their attention and let them know they are not in control, then we have no hope of making anything better, and we can just kind of let it go. I think that saying, no, you're going to, or I'm going to remove the child from your home and find a relative who will comply, or a group home who will make sure the child is getting what they need. Because at the end of the day, that's your job as a parent, to make sure your kid's getting what they need, just like it's my job with my children.
So Natalie, this is John Guynford. I think our paths have crossed probably a time or two in juvenile court.
You are the premier, or at least when I was there, you were amazing with our sexual offenders, and you.
Thank you. I
have an
appreciate
amazing
that.
program.
So on that, I want to talk about, as a clinician, something that's near and dear to my heart. And you've already hit on 2 prongs of this 3-legged stool, so to speak, juvenile justice and diversionary programs and those sorts of things. But I want to talk about the intersection between juvenile justice, behavioral health, and education. And I want to do that just primarily from the point of view of the research and the data that's out there. Louisiana, as you know, has been infamous for incarcerating more youth in the past than any other state in the nation. And Caddo Parish for a while was a hot ticket in that area. And Annie Casey and the MacArthur Foundation came in, and there's been a lot of reform, and we're definitely headed in a positive direction. But there are 2 aggravating factors in my observation, and from the point of view of clinical data, that's still slowing us down. And one of those is the characteristics of kids who end up in the juvenile justice system. And what we know from the research is that some 60% of those kids, that's probably a low estimate, suffer from undiagnosed mental illness. So you hit on that with respect to referring to behavioral health. But there's another aspect of that, and it's research that's come out recently indicating that about 40% of that population suffers from traumatic brain injury. And either one of those things alone, and especially both of those together, can result in behavior that's illegal, it's criminogenic, but it's a manifestation of their disability. Which leads to my next point. One of the highest sources of referral, if you will, to the juvenile court is through the school system and results in what's been labeled the pipeline from the classroom to the courtroom. So what happens with a lot of these kids that are disruptive in the classroom is that because of their disability is that they're arrested or they're referred to the juvenile court for adjudication and disposition on some kind of charge. And the issue with that is that those kids are not being identified by the school system for services that are appropriate to their needs, for all kinds of reasons that we can talk about a lot later if you want to. But my question is this, and what that's resulting in is what Annie Casey and the MacArthur Foundation and the National Council on Juvenile Delinquency and Prevention have pointed to as a criminalization of the disabilities of these children. So to that issue of the pipeline from the classroom to the courtroom, for those kids with those kinds of disabilities, what will you do from the bench when these cases come up for disposition to make sure that those kids have really been evaluated and that history is made clear to the court with respect to that behavior being a manifestation of their disability and appropriate sentencing guidelines for that group?
Okay, well, that's all, I
That's
guess
a big question.
My first thing, it is. My first, I guess, thought is I hope to be able to have a good, I feel like I have a good working relationship with the school board now. I think that I think that juvenile court and the school system need to work in tandem because there are so many, there is just, we both have access to the children. There's not much that I can do about identifying them in the school other than teaching, trying to work with the school board and letting them know what to look for. Because I don't think that there's a purposeful, we just don't care that these children have issues and that we're not looking for them. I feel like most of the teachers that I know they're not aware. They don't know what they're looking for. They're trying to manage 24, 28, 30 children in one classroom, which is, to me, seems incredibly difficult. And even just trying to teach my own children when we were home in March and April, just monitoring too was difficult for me. So I have the utmost respect for teachers. So I don't feel like within the school board the same thing. They're trying to manage, the teachers trying to manage the children. I honestly don't think that there is any purposeful failure to identify. I could be wrong, but that's just my positivity. But I think that teaching them and showing them and having maybe some training so that they can start identifying when these children are young. I think also doing some training with DCFS. I'm sure, I know those workers do know, but they may also need to do an additional training in tandem with the delinquency section, maybe the probation officers, with the DCFS foster care workers, and with the foster parents, so that before they turn 10 and would come to juvenile court for a delinquency or offense issue, then these foster parents can start looking, and it's not just on the school. And it would be fantastic if these parents knew what to look for, but I feel like I work with juvenile court and criminal court all the time, and I can't tell you that I know exactly what to look for in my own children. So I would imagine most parents have no idea, and they're just doing the best that they can. And again, I understand that most of the parents that I interact with, that my kids go to school with, we're incredibly blessed. So they aren't single parents that are working a minimum wage job that have 5 children. So I struggle with how do we let them know that? How do we, before they get to juvenile court? Those are the only suggestions that I can give that would maybe prevent the child from ever coming to juvenile court. But I don't have access to that family until the child is either referred through the school or for stealing a bicycle or shoplifting or whatever, until they come to me if there's ungovernable behavior. So once they come to me, I feel like that's the court's duty via the probation staff to get to know this family and get to know them well and spend time with them, not just a single meeting for after court. I'm, doing a full interview, so to speak, somewhat like when you first meet with a child and you get to know everything about them so that you know what their problems are. You also meet with their parents and possibly their siblings, I don't know, just to get some insight as to what the problem is, because if the mom doesn't actually know, I can't put a name on the problem, she's not going to be, I would imagine most parents aren't going to be able to tell you, because if they know that their child has this traumatic brain injury or has mental health, they would have sought treatment. So I feel like spending a good amount of time on the front end before we decide what needs to be done with them. I think having a probation staff that is putting the effort out on the front end, so you know what your issues are and you can connect them with the right resources and suggest which programs they need to be in and which type of behavioral or mental health or school activities or things that we can do to help them in this educational catch-up. If they're just behind, just different things that child needs to get them where they need to be to have a productive, non-criminal life. And I know it happens because I've seen it. There were plenty of times, and one of them, my most memorable one, it was a child named Brandon. And he came through with about 15 referrals and arrests. And we tried him several times, and it was a Judge Young case, and we were finally able to get an adjudication on the child. I mean, the mom at the time was just like, well, what am I supposed to do? Well, you have to watch him. You can't just let him, you can't just, okay, see you later. I'll see you when you come home. I'm sorry, your son is, 13 years old. Like, you can't just let them go do whatever they want to do, particularly when they're on release for committing numerous criminal offenses, but nonetheless. So we finally got the child adjudicated. So we came through, the probation staff met with them. This was, I would say, within the first 2 years of me being at juvenile court. And they identified some mental health issues. And at the time, the Judge Young suggested that the mom and the probation staff reach out to OCDD, which I haven't heard that term in quite some time. So it kind of makes me laugh. I'm not even sure if that is even an agency. It's kind of like when I first got there, DHH heard about them all the time, and they would come in on our cases. You don't hear about them anymore either.
They keep changing their name.
I'm showing my age. Right. I mean, I'm showing my age when you have DHH and OCDD. But Judge Young had them come in and evaluate the child and got him hooked up with what he needed to do, but also once he was under the purview of the court, like, no, you will be in at night, and mom, he's either going to be with you after 6 p.m. or 8 p.m. weekend, or he doesn't leave the house, and call me, probation officer, saying, you call me if he's not, and we're going to, you have to have rules as parents, or children are running the household, the kids. They're going to do what they want to do. So once we got the child, I think it took one rule to show cause when he first wasn't cooperating, brought him back in, and I think I can't remember if the judge threatened him with, I'm going to put you in jail this weekend if you don't get whatever it is, if you don't get what I'm asking you to get done, or it's, like I said, it was over 10 years ago. It was long before I had my son. So whatever it was, got his attention, essentially, brought him back in. Same thing with mom. Mom, if you don't make sure that he does what he needs to do, or if he doesn't, you don't contact us, then there's going to be consequences for you as well. So so it's basically a warning, but a serious warning. And I think whatever it was, if it was community service or the week in jail, but he held it in abeyance, let him go home. We never saw them again. He never got another arrest. Once they understood, we're not joking. This isn't just a revolver. The child never came back, and he had 15 arrests prior to that point. But we didn't know that he had mental health issues. We didn't know, because we were never able to get him linked up with a probation officer and find out what his problems were. And I don't think, like I said,
Is that me?
No, I think Natalie, you must
We
have.
might have
Natalie?
lost her.
We lost her.
She'll come back.
Hey, can I ask that? And I was running late. Did she ever say what the minimum age a juvenile should be able to be sent to an adult court? Did that ever come up?
That did not come up, but I know they have put 14-year-olds, John, is that right? 14 and 15-year-olds in adult court.
So 14 is the minimum age, Mary?
No,
Is there a minimum
it
age?
takes a court order, doesn't it, John?
I think that's a good question for Natalie, because I think it's in the juvenile code. The juvenile code specifies
Yeah,
that.
well, if
So
she
let's
gets back
ask her
on,
that.
let's ask her that, John, because, that's a big thing. I see some pretty bad kids out there that have already, hold on, guys, there's some.
Fabio.
I muted him. Well, come on, Natalie. She's not back.
Text her, Mary.
Well, I've sent her an invitation again.
I know I got a blog from Zoom yesterday. They had some problems yesterday dropping these.
Yeah, I got totally blocked yesterday at one point on a.
Yeah.
I texted her. I'm waiting for her to come back if she can.
No problem, no problem.
She's trying to get back on now. She just texted me back.
Okay,
She
here.
said she's working on it, and I noticed it said low connection.
I got it. I got her text also.
Oh, great.
You could tell her audio was weak at times.
Yeah, I was struggling to hear it.
The juvenile court, to me, for uneducated observers, like I can be sometimes, is
True to that.
frustrating because I was dealing with some of the police officers who literally were arresting 12, 13, 14-year-olds for armed robbery cases on a bicycle. They'd have a gun with them on their bicycle and stick somebody up or break into a house or, whatever they could get away with because they knew they were going to juvenile court.
Well, they're being used. Those young kids are being used as moles by the guys that are the real criminals because they know that that there are certain restrictions on what kind of sentencing they can receive in juvenile court. I think the other question needs to be, in addition to your question, Larry, is what is the minimal age for involvement in the juvenile court? I think it's 10, but I'm not sure about that.
Well, they at least can have a parent with them at all times, right?
When they go to juvenile court?
Yeah.
Oh, yeah.
Well, I mean, sometimes the accusation is, my child, how can you take him away like that? Well, you need to come with him a lot of the time.
Ooh,
No.
you want to put the child, Marion? You want to put the parents in jail for the children's of
But
mistake?
that's what Natalie was saying. She said you need to, the parents need to be
Yeah, I
strong
heard her.
armed by the judge.
So but listen, and you had me muted, which wasn't a problem. But is she saying that if the parents don't participate, she's going to put them in jail?
She said she's going to bully them
Bully them by putting them in jail?
by telling them you've got to do these things to help your child. And my
And they don't know.
question was, when they have 6 kids and 2 jobs, there's kind of a limit on what the parent can do sometimes.
We know from the research that a big contributor to delinquency is lack of parental supervision. And Marion, that goes back to what you said. You know, what do you do when you have a grandparent?
Oh, here's somebody. Hang on. This is Natalie. Here she comes. Hello there. Connecting audio.
Okay, is it on?
It is on. You're
Okay.
with us.
I'm so sorry, y'all. I'm not terribly tech savvy. I'm a paper kind of girl. So, oh wait, it's both places. I guess it.
We were asking to go on, Larry. Ask your question again.
I'm so sorry again. Please
Thanks,
forgive me.
Marion. Thanks, Natalie, for coming back. Hey, Natalie, you know, there was a lot of discussion about these juvenile court. What is the minimum age that a juvenile can be sent to the adult system?
Okay, so a child. Okay, it starts. A child cannot be held account, cannot be charged with a crime until they're 10. So juvenile court, the traditional age would be 10 through 17, or through the day before your 18th birthday, or where that is where your, I guess, juvenile court's lane. Okay, so there are specific crimes. So I'm still old school. First degree murder, second degree murder, aggravated kidnapping, aggravated rape, which is actually now first degree rape. Those can be at 14. If you commit one of those at 14, there's a specific hearing to the child's. It's about their history, as well as their physical and mental fitness. It has to be done through the court. It's up to the DA's office. The decision is up to the DA's office, but there still has to be, I guess, a fitness test, mental and physical, as well as the child's record. Is there anything in the juvenile system that can address the child's issues, even if they're charged with those crimes? If, let's say, they've never been through juvenile court, then chances are, if they don't have a record, they've never been to secure care, or not even that, but if they've never, like, let's say the child had a school fight once, did either diversion or a short amount of probation, then they would not usually transfer that child to the adult system. He would not be charged in the adult system. When I was there, about, I want to say 6 years that I was in juvenile court, there were only 2 that were ever transferred. One 14-year-old, and it was the first time anyone had done it in the state in years and years and years and years. It was like the first week that I was in juvenile court.
A murder?
It was a murder. John may have been involved with this one. I don't remember I don't know how. He wasn't my case. Like, I literally was my first week there, and I remember watching it. And but he had been to, again, showing my age, Hope Youth Ranch. He'd never been to Swanson, the secure facility, but he had been to a group home. He'd had several adjudications. I think he was on probation or on release with OJJ when I think he shot his uncle. And so he was 15. The discretion is wholly in the DA's office. So if they choose for certain crimes, like I think armed robbery is one of them that can be thrown in. If they choose, then they can transfer you for certain crimes to be tried as an adult. They usually.
We lost you.
Wait a minute. Like, give her a second.
The court
It'll come back.
to agree
Hey, Marion, tell her to leave her video on, but to use her phone for audio.
Natalie, you with us?
Where's Keith Hansen when you need him?
She's still here you with us? She dropped off again.
Billy, call Keith Hansen and see if he can help us.
It's her problem. She has a bad connection. She's doing this from her house, and I think that's one of the dead spots.
She's probably using Wi-Fi, so I don't know if you can hear me. If she comes back, tell her to establish video, mute her computer, call in through the phone, and we'll be at least able to hear her. She's going to need to call the link on the invitation you sent so we can all hear her.
Well, I haven't had anyone else tell me they could not get in, so.
So Marion, she said armed robbery, and you said 12-year-olds that were committing armed robbery. She said armed robbery is when they can elevate to the adult court. So I'm assuming a 12-year-old, John was saying they use them as some kind of a proxy, but just wondering if a 12-year-old commits armed robbery. Huh?
She's coming back.
Okay, if a 12-year-old commits robbery, armed robbery,
they can put him in adult court.
They can put him in adult court. I thought she said
them in adult court.
Well, I thought 14 was the minimum age is what she was saying.
Okay, Natalie. Whoop, she dropped off again.
Yeah.
Hang on 1 minute.
And so, hey, Bob, while we're waiting, did you see any of that RNC last night?
I saw a couple of speeches. I mean, like I watched MSNBC commentary, and they had some of their people on PBS, and they were conceding that Trump is he's a master at the media, and if they thought that he was going to do a suspect job, anyone who thought that was kidding themselves.
Now,
concession.
Well, they could not believe the actual truth about the COVID response that Trump and the American people stepped up to do. They said, "Oh my goodness, he's rewriting history." And I said, "Come on, guys. I mean, Joe and Meecha, I woke up early this morning.
We're not paid to do that, Larry. Come on."
Well, anyway, long story short is they were saying he's rewriting the rule. He's rewriting the history. And I said, "Oh my gosh, you guys have been gaslighting so hard, you don't even recognize the truth. That's just weird."
Well,
Natalie, you with us? Okay, wait, here she comes again. Let's see if this works. Natalie? Hello?
Hi. Okay, I have it on both, so in case one goes out.
Okay, go.
Okay. So, I'm sorry. Of course, when I'm just listening or when I don't have anything that people want to hear, my Zoom works. But right now, of course not. I don't know what this means.
Can you see me? I don't.
Okay, so I don't remember what I was saying.
Here, I'll ask you the question then real quick. What had happened was, what? I'm not sure if she's still there.
Okay, can you see me?
Yes.
Yeah, they can. Natalie, Marion was saying that he knew 12-year-olds that were committing armed robbery. And John says, I mean, can a 12-year-old be sent to adult court? Now, John is saying
No.
they cannot.
No, they would be charged in juvenile court. It's not very common to see the 14-year-old that is
12-year-old.
that's transferred. Like we don't do, or they don't do 14-year-old transfers very often. Like I think I've only ever seen 2. I honestly don't know in the last 4 years, but it's
So a
and armed robbery
12-year-old.
is not, armed robbery isn't, or at least it wasn't the last time I looked at the statute. I have not had an actual case with that. So I haven't had a 14-year-old charged with murder as a defense attorney. So, because it just doesn't happen very often, I guess is the best way to say it. It is reserved, and it is meant from the legislature as well as the DA's office for. It's a very specific set of circumstances. It's children. It's supposed to be children who have exhausted the resources at juvenile court. But the caveat there is that they can only stay. If they are tried in adult court and are sentenced to the maximum, like if let's say they get what is juvenile life, they can only be incarcerated to their 31st birthday. Where any other juvenile that's addressed in juvenile court, it's to their 21st birthday. So if you commit a murder at 14 and are transferred and tried in adult court, then you can only you can only be incarcerated to your 31st birthday, and that would be in an adult facility. Does that make sense? But 15 and 16 and 17-year-olds can be transferred to adult court for lesser crimes. Like I said, armed robbery is one of them at 15, but it is not transferable at 14. But unfortunately, we do have 12-year-olds these days committing armed robbery.
We had several home invasions in South Highland in the last 12 months involving 12, 13, 14-year-olds who had handguns. And I know several of them were on bicycles, and then the older folks showed up with a car to load all the material in, and they took off. But the younger ones were caught. I don't know what happened to them in juvenile court, though.
Okay. This is a big concern for me. When I was prosecuting in front of Judge Young with the DA's office, he did not adjudicate children, whether they were on probation or not. If they were caught with a handgun, he would not adjudicate them delinquent for that. And there would be times that he would not revoke them when they were already on probation and found with a gun. And to me, and I'm not criticizing Judge Young, like he has done a great job, and we didn't always see eye to eye, but I do greatly respect him, and I have no problems with him. However, I feel that things have changed since it's changed since I was in his courtroom when I began there, probably about 10 years ago. So I feel like the gun issue in Shreveport with juveniles is out of control, and they're not being addressed. Like a child on probation, a child shouldn't have a gun unless they're hunting. Like I have no problem with children that are, hunting, but handguns should never be in the hands of a juvenile, first of all. And I feel that it is a huge problem that there are a lot of children that are on probation currently in juvenile court that are running around with handguns, and very little is being done about it. I have been told that they are often seen on, let's say Facebook, people like either the DA's office or the probation staff will find pictures of a child on their own Facebook page holding guns, like pointing guns and stuff, and nothing is done about it. And so to me, that's a problem, and that's a red flag, and that should be addressed before there's a shooting, because you know that child has their hands on a gun. And, you know, it greatly concerns me. It concerns me that our juvenile probation officers are not post-certified, and so they cannot carry a gun. And so many of them feel that they are not safe to go into these children's homes. However, Sheriff Prater has told me himself that he has told them that he will escort them if they would call to any house in this parish, whether it's in the city or in the parish. He and his deputies will escort them anywhere in this parish that they want to go to visit these children in the homes and do home checks and, you know, surprise checks and make sure that they're where they're supposed to be. And it's my understanding that that's not being done. He told me, I've not ever been asked. One of the attorneys for the Office of Juvenile Justice said they have also extended the same. Their officers are post-certified and thus can carry a gun. And they've said, we will escort you to go do checks. And I get it. But at the end of the day, these probation officers are not going and checking these children in the homes, and thus wouldn't know if they had a gun in their room. And if they're not going to their home and asking their mom, they don't know. And I find that a huge problem. I think a parent needs to know what's in their child's room, and the parent needs to know that they need to report it while their child is on probation. I mean, it's not your choice to not report that, because there should be consequences with the court. If you know your kid has guns or drugs in their room and you don't report it to the probation officer, I feel like there should be consequences for that. And that's when, you asked me earlier about accountability. That is a specific example. Or let's say when a probation officer shows up at your house at 10 o'clock at night and your kid's not home and you are. I feel like that's a big problem, because you obviously couldn't handle monitoring your child without help from the court. I mean, you're now in front of the court, and you have to do what the court tells you to do. It's not an option at that point to just, he wanted to go spend the night out. I'm sorry. No. Didn't contact your probation officer and get permission. You don't have, I hate to say you lose those choices, but you have. I don't have a problem. If anyone, I don't care what you're doing, as long as you're not, as a parent, abusing or neglecting your children, and your children aren't committing crimes and victimizing others. I don't care what you do, as long as you're not in front of the court. But I feel at a certain point, there needs to be more accountability for everyone. Like, I don't think children should have guns on Facebook. I don't think children should have guns, period, other handguns. And I don't think they should be doing anything with other guns except hunting. I don't think, if you're on probation, I'm not sure. Hadn't actually thought about that, but I could see where that could be a major problem. But nonetheless, I just am very concerned about the use of firearms by juveniles in this parish, and the lack of response to that prior to shootings. Like in 2018, in October of 2018, I was not working at the DA's office. I was doing criminal defense work, and we got brought in on a child. We got hired, and actually we did it pro bono, but it was a 16-year-old child, I believe. And he had committed a homicide. He shot. It was it's my understanding from my memory, and it was our position that it was a bully in the community. The guy had just harassed him and everyone else. The child had never been arrested, was still in school. I believe had been a child in need of care child much earlier, but had no record and had no arrests. In that same month, there were 6 other shootings committed by juveniles. My child was the only child that was not currently on probation when that shooting occurred, and did not have a record. And that's a problem for me, that 6 shootings occurred while those children were supposed to be monitored while on probation at juvenile court. And I don't know exactly what the fix is, but I feel like we need to do something about it. And all I can do is step up and put my, try and make it better.
So Natalie,
I'm not saying that anybody's doing anything wrong. That's not what I mean, but.
yeah.
So
Kind of a
Natalie, you're saying
two-part-
if somebody bullies somebody, they're justified in shooting somebody? Because if that's the case, Marion, you better start being a little nicer.
No, that's no. What I'm saying is that out of 7 shootings, that was just our position. I'd know, of course, it's not okay for a child to shoot someone for bullying them. But what I'm saying is it's scary how that a child can snap. A child that you had no warning signs, that he did not have any criminal history. It's a scary thought. And it.
Well, that gets back to mental illness.
Separate. Sir?
That gets back to mental illness issues as well.
It does. I mean, but he had no warning. I mean, the school could not believe it. He was not a violent child. It was just, he just snapped. And he doesn't have any mental health. I mean, I don't believe he has any mental health issues now. I mean, he's at CCC, but because he was transferred and tried as an adult, or he hasn't been tried yet. But that's why there's not any resolution. It had nothing. I mean, juvenile court, that's not where his case was addressed. But my concern was that 6 other children that were already on probation also committed shootings, some of them with high-powered rifles into an apartment complex while on probation at juvenile court.
Let me ask one more question on a totally different subject, because we've hammered that one pretty well. Since you've been on both sides, the defense as well as the DA, did you notice any inconsistencies from the DA's office as accusations exist in terms of using their preemptives on Black jurors to exclude?
Do you mean in adult court?
Yes.
I believe I only did one jury trial, the Robert Lynn trial. It was about 4 years ago. I don't recall it being an issue. I would say that, I mean, both of the ADAs were African American, and so
Well, I know that.
I hate to say, okay, so there are always jurors that you want as a DA's office, as an ADA and as a defense attorney. Everybody has jurors that they want. You have, you go into a trial, and I don't think the general public understands this. Jury selection is so incredibly important to winning a case, and it's very difficult in federal court because they don't let you do very much jury selection at all. But you only know what a juror will tell you. So when you have the ability to ask the right questions, and you have somebody, let's say, in an armed robbery trial, or let's say in my armed robbery attempt that ended up being a shooting, this trial that I did, I don't want anybody who's been a victim of an armed robbery or any type of robbery. I don't want their mother. I don't want their cousin. I don't want their best friend as a defense attorney. I want somebody who knows nothing about that. I mean, but if you're not allowed to ask the questions about it, where obviously the DA's office wants somebody, that's the kind of juror that you want, someone that's gonna empathize with you. Okay, so I also, as a defense attorney, I would want, let's say you would think that you would want the mother of someone who had been accused of, whether it was rightfully or wrongfully. As a defense attorney, you want someone that's going to empathize with your client. So I think at times it comes up looking like it's about race, but it's not. Oh, I mean, I'm yes, there are certainly times that it has been, but at the end of the day, when you look at the numbers of people being prosecuted, which I don't have the answer for that. Yes, I would say there's probably at least 95% of the children who come through juvenile court, between 90 to 95% are African American. I don't know how to fix that. I don't know what the answer for that is. And I certainly glad that it's not my problem to fix, because I don't have any answers. But so it's similar numbers, not quite as high, I don't think, but similar when you're looking at the Caddo Parish District Attorney's defendant pool, let's say. So most of the people, not most, many of the people that have been charged or have family members that were charged with armed robbery are going to be African American. So the DA's office does not want the mother of somebody accused or in jail for an armed robbery. They don't want their best friend. They don't want their girlfriend. They don't want anyone with any relation to somebody that has been arrested or charged, rightfully or wrongfully, of an armed robbery. So all of those African Americans. Do you see what I'm saying? Like,
Yes.
So I have not ever seen, and I have not seen Bozier do it. I have not seen any Webster do it. I have not personally, and Eric and I have talked about this extensively, and he's been doing it for 27 years. And he's like, not any, and I hate to say this, and I don't mean it in like a joking way. He says, not any more than I do it or anyone else does it. Like, I know it's not about race. It's about, like, let's say Eric is not going to want somebody that is wearing a Trump shirt on his jury for an armed robbery that turned into a murder. That's just, you have to go by, and it's not because that person's white or black, doesn't matter. You don't want the person that's, do y'all understand what I mean?
It's a known bias.
Right. It's not really about the race. It's about so many more factors that come into it. It's the same thing, I would imagine, John, like in a sex case. You don't want the district attorney would love to have somebody whose daughter, had been the victim of some sort of sexual assault, but the defense attorney wants no one that has anything to do with that. Do you see what I mean? And so it ends up coming down. Yes, it can come down to race. That's why they require you to have a race neutral reason. But then you fall back into, well, the number of people that, and some of those you can have for cause, but that's just the easiest example that I can give you. Oftentimes it's about their political views. It's about their history, their closeness with somebody with a crime, or, if they've ever been a victim of a crime or things like that. If they've ever been on a grand jury, which we learned, which I explained to him, they're usually tend to be aligned with the DA's office, even though they're not on grand jury anymore. They just get to have a good relationship with the DA's office. And usually by the end of your jury service, your grand jury service after a year, you've gotten to know and like and trust whichever ADA you're dealing with. So when you're in a general jury veneer, you already have a trust, let's say. For most of the time, you have a good relationship with someone in that DA's office. So you're going to be more inclined. It's just the way that it is. Well, the man happened to be black. So we did not want him on our jury. It had nothing to do with him being black. It had to do with the fact that he had served on a Caddo Parish grand jury the previous year, and thus had a good relationship with the Caddo DA's office. So no, I'm so sorry. That, to me, I have not seen that, but I certainly don't do jury trials all the time anymore. We don't do very many. They just don't go to jury trials. So I don't feel like my clients were ever treated unfairly, but it is very different when you have private counsel, and I understand that.
No, you want to go back to something. The question I asked you at the beginning of this interview kind of put you on the hook a little bit, and now I'm going to give you a chance to get off the hook with a different kind of question. Just from my outside view of the juvenile court, it looks like it's the end process for a lot of what didn't work in the life of these kids. and that's why they're ending up in juvenile court. You talked about accountability, and I couldn't help but wonder, if God waved his hand and all of a sudden we had appropriate supervision of all of these kids, how many of these problems would we have?
Right.
So we go back to what Marion said earlier about, the grandmother who has inherited 6 different grandchildren, and she's working 3 jobs to support them. And she just is not capable of providing that supervision. And I know I've had these grandmothers in my practice when I said, what is going on? Why are these kids? What are you going to do to make sure that this one juvenile out of 6 is not repeatedly landing in the juvenile court? And what they tell me, I think once they get to trust me and they know that I'll understand, is I'm a submarine underwater and there's a torpedo coming and I've got to decide which compartment I'm going to take it in and who's going to drown so I can save the others. That's a harsh reality. So when that presents itself in court, I wonder sometimes if what's going on with these kids who are carrying guns, if part of the solution is not just simply a change in geography to some place where they can receive the supervision that they need to get them out of the culture that they're in that's promoting all of that.
That's what I meant. I do, like I said, I do struggle with what is the answer for those moms and grandmothers.
Yep.
They are doing for the most part, they're doing the very best they can. And I'm not saying if you're cooperating with the court, you are being, you're accountable.
Yeah.
Like I'm not looking to harm or punish anybody. That's not what I mean at all. And I have to say, as much as scared as I was when I left the DA's office about doing criminal defense work, because I felt like I had the heart of a prosecutor, it was the best thing that ever happened to me. It gave me a completely different perspective, whether my client was guilty or not. I knew I didn't have, even if I had the prosecutor with the very best case, like my client is so very guilty, I still didn't have all the information. And I did not realize that till I'd been on the other side, whether it was helpful information or not, but they might have been molested or, there were so many things. And as a private defense attorney, you have the ability to do, evaluations and find out what the issues are. And then we present that to the DA's office. I feel like it's a similar thing when you finally get these kids in front of you, as the court, and trying to figure out what is going to help this grandmother the most. What does the child need? So like hooking them up with different services, if it's mental health, if it's behavioral, whatever it may be. If they need transportation to and from those services, I get it. If grandmother's at work, how's the kid going to get from school to their provider? And I think working on some of those things making those connections where grandmother doesn't know how to make them, doesn't know who to contact. I need help. I just don't know who can help me. If it is something where the child needs to be supervised and grandmother is at work, maybe finding the right program that either is a nonprofit and would allow the child to do whatever activity it is, so the child is monitored, whether it's that way, finding that connection. What can this child be into that hopefully they will like, that they will take an interest in, that at least can occupy their time and make them feel good about themselves. Even if they don't like it, get the energy out to be able to bridge that connection to where grandmother or mother can pick them up and then get them home where she can monitor them. Whether it is, like after school programs, making sure if it's in the morning, like if mom leaves for work at 5 a.m. and the children may or may not make the bus, maybe trying to figure out a way to where there is a neighbor, somebody that we can, trying to help these people figure out what is going to make their lives better. Does that make sense?
It does. It makes a lot of sense. Yeah.
That's what I would hope. The probation staff, I know they're great at that, is getting to know